So, you're in a dispute. Should you take court action? I'm going to talk about 5 points to consider in answering that question. And this is all about protecting yourself before, if and when you issue a claim. Number 1, is there a complaints process that you should follow first? Number 2, do you have any contractual obligations to do anything different? Number 3, should you consider an alternative form of dispute resolution? Number 4, have you complied with any pre-action protocol? And finally, number 5, does it make economic sense to do so? So, you're in a dispute. Is it correct for you to take court action? Issuing proceedings is a huge investment both in time and money. And I would always urge clients to consider a range of factors before firing the pistol, as it were. 5 points I would suggest. Firstly, and subject to the nature of the complaints and the status of the defendant, is there a complaints process that you should have followed? If it's a public body, if it's an organisation, if it's a public service, they will no doubt have, and they are obliged in fact to have a complaints process, and that should be followed in the first instance. And indeed the court will take a very dim view of proceedings being issued prematurely if that process hasn't been followed. Number 2, are there any contractual obligations for you to try and resolve the dispute without going to court? So very often, certainly in commercial contracts, there will be some form of dispute clause or dispute mechanism that the parties are obliged to follow first. So I would consider any contractual obligations you have, because again, if you don't look there first and if you don't follow what that says, you may put yourself in breach of a contract before you've even started the process. Number 3, is it appropriate to consider what the law calls alternative dispute resolution, or ADR as it's commonly referred to? And all ADR is a recognised mechanism for resolving disputes outside the court process. The courts are increasingly keen on parties to use different forms of ADR, and there is an obligation on all parties to a dispute to consider whether ADR is appropriate. Subject to the nature of the dispute and the position of the parties, it may be that ADR is appropriate in your case. That may be ongoing negotiation, it may be some form of mediation, it may be the joint appointment of an expert to narrow the issues. All things to consider which might ultimately save on time and costs moving forward. Number 4, is there a pre-action protocol that needs to be followed? So the court provides for a number of what they call their pre-action protocols, which may be different depending on the type of dispute. So if there's a construction dispute, or if it's a professional negligence dispute, or if it's a debt recovery matter, the court have a series of procedures that need to be followed before claims are issued. And it's very important that parties follow those, because if they're not followed, it's highly likely that a court will penalise a party for failing to do so. What is the protocol? Well, in very broad terms, and they all vary slightly, but they all involve what's called a claim letter written from the prospective claimant to the other side that will set out the claim. And the idea is to ensure that both parties understand their own position in the dispute and can make an informed decision about what to do next. And finally, and perhaps most importantly, is the economy of issuing proceedings. And this really boils down to 2 things. Firstly, the cost versus reward of issuing proceedings. How much, if it's a monetary claim, how much are you looking to recover, and what has your lawyer told you about the costs of proceedings? And this is fundamental, because you won't necessarily stand to recover your costs even if you're successful. So you need to think long and hard about the economy in issuing for an amount of money if your costs are going to be substantial. And secondly, recoverability. So how likely is it, if you issue a claim and you're successful, how likely is it you'll be able to recover those monies from the other side? Again, fundamental to the economy of issuing a claim, because as the law often refers to a man of straw, there's no value in pursuing somebody for a remedy if they simply don't have it. So all factors to take into account before you consider issuing proceedings, and all factors that are important with what your ultimate cost liability may be, and factors to take into account in protecting yourself against any adverse rulings by the judge. Ultimately, issuing proceedings, the rule is to put yourself in the best position you can be in before you pull that trigger.